The bedrock of commercial law is the doctrine of privity. It dictates a contract is an impenetrable bond formed exclusively between the agreeing parties. Because of this doctrine, a contract only creates rights and obligations between those specific, actual parties. A stranger to the agreement cannot step in to enforce it, nor can they be bound by its terms. Strict privity presents an immediate mathematical problem for commerce. A multinational corporation cannot legally function if every single supplier contract, employment agreement, and real estate lease requires the chief executive's direct personal signature. This slide directly states the necessary legal workaround: agency. Agency operates as a designated exception to the doctrine of privity, allowing an intermediary to negotiate and sign on behalf of someone else. Agency is a legal fiction. It permits a stranger to entirely bypass the wall of privity, successfully binding two distinct parties into a contract through the actions of a proxy. Every agency relationship relies on a three-node transaction: principal, agent, and third party. The maxim is qui facit per alium, facit per se. The agent steps into the principal's shoes. But who bears liability if that agent goes rogue, commits fraud, or destroys property? To untangle those liabilities, courts use the IRAC methodology. It stands for issue, then the rule, then the application, and the conclusion. It's a rigorous framework for isolating problems, applying laws, and determining outcomes. To resolve any issue regarding who pays for a rogue agent's actions, we first need to define the rules that govern the agent's specific authority and their internal duties. This lecture slide breaks down the first rule of power: actual authority. This is the express or implied power granted internally, entirely through mutual agreement between the principal and the agent. We contrast that with apparent or ostensible authority. Unlike actual authority, apparent authority is generated externally. It is created by the principal's outward actions and statements to the world, regardless of what private agreements they have with their agent. Apparent authority manifests through a mechanism called agency by estoppel. Estoppel is a legal principle that prevents, or estops, a principal from denying an agent has authority if the principal's own actions suggested otherwise. Looking at the specific requirements for estoppel, first, the principal must make an express or implied representation of the agent's power. Second, the third party relies on that representation. And third, they alter their position, like signing a contract, because of that reliance. Once those three requirements are met, the principal is legally bound to the contract. This holds true even if the agent had absolutely zero actual authority to sign it. There is also a post hoc rule called ratification. If an agent acts completely without authority, but the principal decides they actually like the resulting deal, the principal can retroactively adopt those acts, formally binding themselves to the contract after the fact. In commercial law, a principal's legal exposure is defined by what they broadcast to the world, not just what they whisper to their agent. While the agent wields immense external power to bind the principal, the law imposes heavy internal restrictions to keep that power in check. The relationship is inherently fiduciary. This text defines a fiduciary as someone holding a position of trust, carrying a strict obligation not to abuse that trust. The first major fiduciary restriction is financial. An agent is absolutely prohibited from using their position to make unauthorized profits, take secret commissions, or accept bribes from third parties. The second major restriction addresses motivation. An agent cannot allow their personal self-interest to conflict with their strict duty to execute the principal's goals. This relationship is reciprocal. The principal owes duties to the agent as well. They must provide the agreed-upon remuneration, and they must indemnify, or reimburse, the agent for any liabilities and expenses properly incurred while carrying out the agency. Fiduciary duty serves as the rigid internal control mechanism. It is designed specifically to prevent the agent from weaponizing delegated authority against their own principal. When it comes to external liability on the contract itself, the general rule is clear. If the principal's identity is fully disclosed to the third party, the agent faces no personal liability on the resulting contract. They simply drop out of the equation. There are exact exceptions where the agent is personally exposed. This happens primarily if the agent contracts entirely outside their actual or apparent authority, or if the principal they claim to represent is factually non-existent. a concept explored in Kellner v. Baxter. Moving from contract to tort law, which governs civil wrongs like negligence, the baseline rule shifts. An agent is always held personally liable for their own tortious acts. If they break something, they are responsible. However, this triggers the doctrine of vicarious liability. As outlined here, the principal is simultaneously held liable for the agent's torts, provided those torts are committed within the scope of the agent's employment. The boundary here is strict. Vicarious liability only attaches to the principal if the tort occurs while the agent is executing their designated authority. The law forces the principal to absorb external risks to ensure innocent third parties are compensated, provided the agent was operating within the established matrix of the agency. Let's apply the IRAC method to a hypothetical fact pattern. A corporate principal hires a purchasing agent. Internally, the principal formally limits the agent's spending power to exactly $10,000 per contract. Then, the principal makes an error. They send an introductory email to a new third-party supplier stating, "My agent handles all our procurement." They fail to mention the price limit. The agent goes rogue. They sign a $50,000 contract with the supplier, completely ignoring the internal limit. Worse, the agent pockets a secret $5,000 kickback from that supplier for securing the massive order. Finally, while driving a company vehicle to deliver the signed paperwork, the agent negligently crashes into the supplier's loading dock, causing severe property damage. We apply IRAC to the first issue, contractual liability. Does the $50,000 contract bind the principal, even though it violates the strict $10,000 internal limit? We apply the rule of estoppel. The principal's email was a clear representation to the third party. The supplier relied on that email and altered their position by signing the deal. This creates apparent authority. The conclusion: the principal is legally forced to honor the $50,000 contract. The external representation made to the supplier overrides the internal limit placed on the agent. Now we address the internal issue. How does the law handle the agent's secret $5,000 kickback? We apply the fiduciary duty rule. Taking a kickback is an egregious violation of the prohibition against unauthorized profits and conflicts of interest, as established in cases like Lintros nominees. The conclusion for this issue: the agent breached their fiduciary duty. They are entirely liable to the principal for that $5,000, and the principal has the right to sue the agent to recover those funds. Finally, we address the tortious issue. Who pays for the loading dock destroyed by the agent's negligent driving? We apply the vicarious liability rule. The critical question here is whether the negligent driving occurred within the scope of the agent's employment and authority. Because the agent was driving a company vehicle specifically to deliver the contract, an act executing their apparent authority, the negligence falls directly within the scope of employment. The final conclusion: the principal is vicariously liable. They must pay the third party for the damaged loading dock. However, because the agent committed the tort, the principal retains the right to seek indemnity, suing the agent to recover those damage costs. Looking at the final financial architecture of this scenario, the principal absorbs the heavy external blows. They are chained to the $50,000 contract and the property damages. Despite the chaos, the agent successfully performed their core legal function. They bypassed the wall and created a state of privity directly between the principal and the third party. The agent, meanwhile, is erased from the external contract, but their protection evaporates internally. They are now the direct target of litigation from their own principal for breach of fiduciary duty and tortious indemnity. A principal's financial exposure is dictated by the external reality of estoppel and vicarious liability, not the private promises they make behind closed doors. Agency is the indispensable engine of global commerce. It allows businesses to scale beyond a single individual, but it is a highly volatile legal fiction that demands strict adherence to its rules to contain the cascading risks of delegating power.